Hello friends, this is the Lincoln Lawyer coming to you from an undisclosed location in Fort Lauderdale. I think everybody's dead except me. Apparently, it's a lovely day here at my home. Just kidding, it's just some restaurant. So anyway, today we're going to talk about suing China, litigation against China. There's a lot of talk about that shit now. Congress is trying to pass a bill. So we're going to see how that might work. Okay, so there's an act called Foreign Sovereign Immunity Act of 1976 that limits liability for foreign states for various acts of foreign states. And there's a couple exceptions in it, actually, like 3 that I'm going to discuss in a minute. So I'm not sure that a new act is actually needed. So I think sufficient basis exists to sue China under the existing law, but Congress can make it easier if they want. So we're going to discuss that now. So this Act, 28 U.S. Code 1605, let's go through a couple exceptions real quick and see if any of them might apply. A foreign state shall not be immune from the jurisdiction of courts of the United States or of the states in any case. Okay, so these are the exceptions. Number 1, in which the foreign state has waived its immunity either explicitly or by implication. So explicitly or by implication, waiver. Waiver is conduct inconsistent with a known legal right. Okay, conduct inconsistent, what could that be? Well, that could be a settlement, for example. Let's say a company, strategic partner of China, the communist government, demands money. Says, well, we've lost a lot of money, we've lost billions of dollars as a result of the shutdown. We need some money, help open up, and China says, okay. So they pay the money. So that would be waiver, possibly, potentially. Okay, so that would be conduct that is inconsistent with a known legal right. Conduct inconsistent would be, they would be denying their liability for the shutdown. Okay, since it's an accidental, they're claiming it's accidental release and they had nothing to do with it and it just happened, and they claimed U.S. military released the virus, yada yada. So conduct inconsistent would be payment of money to a company, damages. Okay, so by paying that money, that could be seen as an admission of some kind of culpability. Not liability, but culpability. Okay, so that could be a waiver. All right. Number 2, in which the action is based upon a commercial activity carried on in the United States by the foreign state. Okay, international air travel is a commercial activity. All right, or upon an act performed in the United States in connection with a commercial activity of the foreign state elsewhere, or upon an act outside the territory of the United States in connection with a commercial activity of the foreign state elsewhere, and that act causes a direct effect in the United States. Again, international air travel is a commercial activity. So viral research, release of the virus, cover-up, that would not be a commercial activity. Commercial activity would be airline, passenger, travel, international. So we know, generally speaking, that they pretty much cut off national travel within China once they found out the virus was coming out, and they failed to stop international travel. A lot of people got out. Some say tens of thousands, hundreds of thousands, could be 500,000 of people, and they, consequently infected a shitload of people. So that would be a commercial activity. So you could say an act performed, all right, in the United States in connection with a commercial activity, or upon an act outside the territory of the United States in connection with a commercial activity. So an act performed, that could be a failure to warn, a failure to stop international air travel. That could definitely be it. So I believe there's already a lawsuit out of Florida based on this particular exception number 2 to 1605, 28 U.S. Code against China. Okay, so let's look at number 5. This is the final exception that we're going to talk about. Not otherwise encompassed in the paragraph above, in which money damages are sought against a foreign state for personal injury or death, or damage to or loss of property occurring in the United States and caused by the tortious act or omission of that foreign state or of any official or employee of that foreign state while acting within the scope of his office or employment. Tortious act. Okay, tortious act would be negligence, gross negligence. That would be a tortious act. So negligence would be failing to warn. Okay, failure to warn other countries, the world, that they had this particular pandemic going on in their country, that it was highly contagious, and omission to prevent international air travel. I mean that's pretty well encompassed within this particular exemption. So acting in the scope. So yeah, there would be some respondeat superior. All the actors, the workers for the facility, the viral research facility, they would be agents of the state, and the people who handled the pandemic in Wuhan, they would certainly be agents of the state. The people who failed to prevent international air travel, they would definitely be agents of the state. So this is pretty clear cut. I think there's definitely a case under this particular exception. So money damages are sought for death or injury, bodily injury, damage to loss of property. It's pretty clear right there. A lot of property loss, a lot of death, a lot of personal injury, medical injuries, tortious act or omission. Omission, failure to warn, failure to disclose, a lot of stuff. Alright, so I think there's sufficient causes of action under this particular act that's already law to sue China. Okay, so I'm going to discuss problems with this particular plan at the end. Okay, so I'm just going to go through some of the issues that need to be addressed in any new act passed by Congress that, they need to cover as far as lawsuits against China. So plaintiffs, okay, plaintiff victim class. Who is going to be able to sue China? Alright? If you're hearing some construction noise, then, I'm sorry. I apologize ahead of time. Anyway, so can individuals sue, or does it have to be class action? That is the issue, okay? They have to define the plaintiff class, okay? So clearly, lost wages, that's damages, okay? But then a lot of people received unemployment, so they can't double collect. So it has to be lost wages minus unemployment. That's a much smaller amount. Okay, so they could sue for that amount. That wouldn't be much to sue, much to get a lawyer over. So that would probably need to be a class action. So I think probably class action is the best way to go here. Lost businesses that, defaulted on their lease, their lease payments, their obligations to vendors. Is that a class, potentially? That could be a class. Lost homes, that would be consequential damages. Lost homes, lost commercial property. That would be, consequential damages. You lost your business, you can't pay your mortgage, you can't pay your rental payments, you lose your business, you lose your home. So that would need to be defined in any statute, okay? Medical bills. Can medical bills be collected? All right, so there's tons of dead people, all right, 40,000 or so dead people, but there's a lot more people that have been in the hospital and survived, all right? So they're going to get medical bills. That's a shitload of money, all right? Shitload. I mean, that's not free, right? So they're going to get medical bills. Are those going to be covered? That sounds like a class action. All right, that should probably be under class action. All right, so if you're on a ventilator, I mean, for a week, 2 weeks, that's 100 grand, 150 more plus, 24-hour care. That's a lot. That's a big bill. All right, wrongful death. A lot of people, 40,000 dead people. Can families of people who died sue for wrongful death? That's a big question. All right, I think they should be allowed to sue. Technically, that's that is wrongful death. If China released the virus negligently, gross negligence, yeah, that's a significant, that's a very reasonable wrongful death lawsuit. All right. So what about insurance companies? Can insurance companies sue also? Insurance companies have to pay billions and billions. Medical, business claims, all kinds of business termination, business interruption, mortgage, failure to pay mortgage, mortgage insurance, all kinds of insurance companies getting hit up for just absolutely astronomical sums. Can they sue? That's the question. I don't know. I mean, theoretically they should be. I mean, those are damages directly related to the pandemic, directly related to China's actions in failing to stop international travel, in failing to warn the world of the contagious nature of the disease. So I mean, I think there should be, this should be a class. This should be a class action right there. For insurance companies, all get together and sue China, okay? All right, theories of liability is pretty basic. I mean, it's going to be negligence, gross negligence. There's no intentional tort that would apply to this, but Congress can create a new one in a new act. They can create a new tort, intentional failure to warn of a contagious pandemic. I mean, failure to act to prevent the spread of a pandemic. I mean, there could be a number of causes of action that could be created against China by Congress, okay, in tort. So respondeat superior, vicarious liability, certainly everything that China did was a result of its agents, and therefore, you know, it would certainly be, and lawsuits would be against it, China, the government, the Communist Party of China, through its agents, okay? So the actions of its agents. Business interference, you know, business interference, that's a tort, all right? That could also be a class action, a cause of action. All right, now standard of proof, generally speaking, criminal cases, the standard of proof is going to be, you know, beyond a reasonable doubt. That's like 90% plus, okay? Civil cases, it's lower, it's preponderance of the evidence, more likely than not. That's 50% plus. If you can prove 50% plus, more likely than not, then the defendant will be liable and they'll have to pay, all right? That's going to be judgment against them. So there needs to be hard evidence that the communist regime was negligent or grossly negligent in not closing the international travel. So there needs to be some kind of communications intercept. There needs to be assistance from the federal government. They should provide evidence. A lot of the intercepted documents, communications that the intelligence community has that we don't know about, emails, etc., tapped phones, you know, that they've obtained from satellites, that talk about knowledge, scienter, knowledge, foreknowledge of the pandemic that they had and the contagion factor of the disease, that, you know, they should, that would be evidence. The federal government needs to provide that evidence to all the plaintiffs to assist them in this litigation, okay? So there's some reports that the whistleblower has provided written documentation that you know, the virus was lab origin. It was being experimented on in a lab and accidentally, negligently, grossly negligently released. So that would also potentially be a cause of action right there. Okay, so that would be much easier to show if there was written documentary evidence that China's government actually knew that this was a lab research virus and it was released by accident or otherwise. That such evidence was obtained by the federal government and provided to the plaintiffs. All right, statements by the Chinese government blaming the U.S. military and otherwise, you know, denying liability, blaming other parties, etc., they would be admissible in court to show knowledge and dishonesty that the communist regime was denying liability that it knew about, but, you know, publicly they were saying that they weren't responsible. So that would be very strong evidence, okay? So then there's the thing with China buying up all that PPE and hoarding it when at the time they knew that they had a pandemic, all right? They bought up a shitload, millions of PPE, protective masks, gloves, etc., all kinds of stuff, with the probable intent to resell it back to infected nations at a later point at a significant markup price, okay? This was a business venture for them, apparently. So if it can be shown that they actually bought up a shitload of PPE during the time when the pandemic was starting in China, and later they resold it at a marked up price back to, you know, other countries that were infected, then that would certainly go to show scienter, knowledge, foreknowledge, intent, and you know, it would be very strong evidence of cover-up. And finally, there was apparently a pandemic clause in the final trade agreement that they came to with the White House, with the administration. There's a pandemic clause, force majeure clause, where they would be excused from performing if there was some particular calamity, such as a pandemic, okay, or whatever catastrophe they had in there. I haven't seen the actual agreement, but that's my understanding of it. So if they actually inserted that force majeure pandemic clause into the trade agreement, which excused them from performing at a time when they knew that they had the early kindling of the viral breakout in China, in Wuhan, that would certainly be significant evidence to show a cover-up, okay? Cover-up would be negligence, gross negligence. It depends, whatever the standard of proof is, whatever Congress decides to make it. I'm not sure, but I think they should make it negligence, actually, which would be easier to prove. Negligence, I think there's more than enough evidence for negligence, and particularly if you include any written documents of a cover-up and written documents of internal knowledge that the virus was lab-based, escaped the lab. So, putting that force majeure clause, the pandemic clause in the trade agreement that would excuse performance in case of a pandemic, I mean, that would be very strong evidence of foreknowledge, and then consequently negligence of, when they failed to warn the world what they had going on in their country. Okay, so ultimately, I think this is still going to be an uphill battle, okay? Because, look, let's say all these plaintiffs sue, let's say people sue, business owners sue, class actions, they get, 500 lawyers, the biggest law firms in the country to represent them, yada, yada, and they're great, brilliant lawyers. They go through this act, or maybe another act, a congressional act, and they win. Okay, how are you going to collect it? How are you going to collect that money from China? This is, China isn't going to pay. They're going to ignore it. They don't give a shit. So what I think, my own opinion, okay, is the Congress should make this a cause of action for states, municipalities, governmental regulatory agencies. Okay, they should be able to sue on behalf of individuals and other parties that have lost. Okay, I think that's how this litigation should occur. All right, so municipalities and states that win litigation, they're going to win billions, trillions of dollars. Individuals and law firms are not going to be able to collect. They're not going to go to a court in China and say, well, look, we won this judgment in America, give us the money. Okay, that's not how it's going to work. So if municipalities and states, governmental organizations win their lawsuits, then they can go to the federal government to enforce those judgments, okay, potentially. And the federal government, all right, can obtain those funds from debt that China holds, from bonds, treasuries, okay, and other holdings in the U.S., such as real estate, businesses, etc. They all own all kinds of stuff, property. They can put liens on Chinese property. I mean, this would definitely be very controversial, canceling treasuries, canceling debt, canceling trillions of dollars of U.S. debt to China. I mean, that would be extremely, extremely detrimental to relations with the two countries. I mean, it might maybe irreparably, all right? It might not even be possible to salvage the relationship, okay? So, but I think if the federal government wants to be able to collect any of those funds that a court may potentially award plaintiffs, which it seems like there's a very strong case, generally speaking, I think it should be the states and local governments, cities, that should sue on behalf of their residents, their constituents, all right? And 50 states can file 50 separate actions on behalf of their residents and then hand over the judgments to the federal government for enforcement. And then Trump would do whatever he feels is reasonably necessary in collecting those judgments, whether it be hiking tariffs by doubling the tariffs, whatever, canceling the debt. I mean, they're going to monetize the debt anyway. They're going to lower that debt. So I'll go into that in another, economics-based video. But a lawsuit is going to be an uphill battle. But I think there's more than enough evidence of a cover-up, a failure to warn, failure to stop, to restrict international travel, and spread the contagion. So I think I'm going to kill it right here. 20 minutes, that's going to be a good record for me. I hope you enjoyed this video. I hope you found it informative. I am the Lincoln Lawyer. Like, subscribe. Keep watching for more. Stay safe. Be cool.